right. Yeah. Can you hear me? Yeah. So, thank you very much for the invitation. It's an honor for me to speak to you today. I am the General Counsel of SAP. It's better. Okay. Fine. I will fight with it. Okay, it's all right. It's all right. It's all right. So, while serving the ice cream, I will give you some. Let's see how it's going. Can I have my presentation as well? We need to switch. Computer switch. Okay. All right. We already have Philip. All right. So before during while you're getting the ice cream, I'll give you some advertisement of our company. So the company is 40 years old, or 41 years old, just 11 years older than this organization, and you probably have heard about our company. It's SAP. It's the largest European-based software company. So advertisement over. Coming to the topics. I'm the head of the Global Legal Department. The Global Legal Department was established in 2008. Before that, we had decentralized legal departments reporting to the MDs or to the CFOs of our subsidiaries. Then in 2007, we have decided to create a Chief Global Compliance Office because of the histories, tales, stories, or whatever we heard in Germany about other companies having problems with bribery matters. So with that, are we really situated well? And we thought not, and we said we should have a centralized global compliance organization. Then 1 year later, the global centralized legal organization followed. We had some acquisitions, and now we have integrated all lawyers to one organization. I'm reporting to the Chief Financial Officer, who is a board member according to the German law. And we do have approximately 400 persons in our legal department, so a mid-size international law firm. These are the practice areas. I don't have to go into much detail into this. I think that you are very much familiar with that. What is the position and how do we see the Global Legal Department SAP? And this is also, I think, referring to what Philip already said to us. We see ourselves in twofold positions. On the one side, we feel that we are business partners within the company. We are giving advice, help closing deals, help structure contracts, giving tools to not just the legal community only, but also to the salespeople, to the development people, to the executive board, you name it. This on the one side, our position, our role as company lawyers. On the other side, on the left side, you see that we feel also to be stewards of the company. And this is pretty much closer than maybe to the legal advisory role of the legal counsels. So we are trying to protect our company, but also try to comply with the law, giving advice to the company, to the executive board, or to whom else, in order to be in compliance with the law. And this picture you see in front of you has been developed from a picture which the Global Finance Organization see itself as well. So they have a similar picture. So you see that this is also fitting within our company, at least in the sport area of the Chief Financial Officer. What are the reputations today for company lawyers from the inside view and the outside view? First of all, I would say that we already have passed the status of being only naysayers. This was something, of course, everybody was talking about. If I'm going to the legal department, I just hear, no, this cannot be, and you have to rethink your business plan. What we have achieved today, we are at least bottlenecks, and maybe also trusted advisors. I think this would be the ideal situation, how we can see ourselves as in-house counsels being trusted advisors. Then, of course, we have a compliance function. Notwithstanding whether we have an independent compliance organization within the company, but being lawyers, we also have a compliance function. And this within SAP is related to insider law, and regulations, and of course also to prevent the board to do anything against the law and to be cautious. And then, of course, we have also learned lessons from bad experiences. So if you are an in-house counsel lawyer of a company who have never made bad experiences, on the one side, this is very positive for your company, for yourself. On the other side, if you have already some bad cases, then it's really helpful for the in-house counsels. Maybe not for the in-house counsels who handled these bad cases or were in-house counsels before the bad cases occurred, but at least then for the successors of these in-house counsels. Because these bad experiences gave examples to the management that legal advice is necessary, that legal advisors have to be asked, and also the legal advice has to be followed on. And at least our company, we have made one big bad experience, and this gave us a lot of lessons to learn, and which has, I would say, really strengthened our position as an in-house department, legal department, also as in-house lawyers. And I've never heard, when we have talked about these bad experiences, that everything would have been better if we would have engaged outside counsels. So management is aware that in-house counsels are very helpful, maybe not for the day-to-day business only, but also that in the right moment they have to raise their hands and say, no, this is against the law. And this is really appreciated, not maybe at that moment, but giving all consequences which might appear if they do not follow the advice, I would say this is absolutely positive. Then, as legal advisors, from inside view, we are the single point of contact, or we should be the single point of contact with respect to outside counsels. I would say the situation where board members or managers are dealing independently with their outside counsels is something which we should not tolerate, or at least try to argue against it. Because then, as in-house counsels, we do not see, or we do not even hear what kind of advice has been given. Also, the selection of outside counsels may be somewhat random, so might be some golf partners or neighbors. And so this is something I think we really should have an eye on, that the single point of contact should be the legal department. From the outside perspective, this will be seen maybe a little bit negatively, because you do not, as an outside counsel, have a direct access to the CEO, CFO, whosoever, and you always have to go to the general counsel or to the legal department. On the other side, if outside law firms or outside counsels see it in a realistic way, they will also recognize that this has also advantages, because the in-house counsels, they already are filtering facts, bringing together all the facts, and then giving facts to the outside counsels in order to ask for very specific advice on specific matters. And, of course, related there with is also the coordination function of the legal department. Responsibilities and liabilities of company lawyers. So we do give legal advice. This is nothing different to our outside lawyer colleagues. If requested, sure, but on the other side also proactively. And I think this is a big differentiator, or can be a big differentiator compared to our outside colleagues, because we are living in the company. We know what's going on and what tendencies are, what new business models are coming up. And this is something the outside counsels cannot really know about. So they are really relying on the request that we are asking, that they give us legal advice, whereas we as in-house counsel, we only can have a steering position, steering role, or even a leadership position, and giving already advice whether this direction might be, from a legal perspective, the right one, or maybe not the right one. As I said, we have a very good overview about the operational functions, and therefore this is really helping the management. Then, as in-house counsels, we are loyal to our employer. And maybe we are very conservative, at least even in our industry, in the software industry, where People may not be so loyal to their employers. The legal counsels are staying for a long time. So we are loyal, but on the other side, we feel also very loyal to the law, and at most to the law. And this is something which we really have as in-house counsel also to demonstrate, not just outside, arguing with the commission, with the courts, with the public prosecutors, with whomsoever, but also in-house. We cannot say, dear Mr. Prosecutor or dear Mr. Commissioner, we are lawyers, attorneys, and so please give us privilege. But if we are not acting accordingly also in the day-to-day business within our company. So we feel also being lawyers, attorneys, in-house attorneys, and our partners in the discussions in the companies are clients. This is something which I really have noticed with our younger and junior colleagues. They are not talking saying, okay, I have spoken with Mr. Miller from that department. They are saying, I have spoken with a client. I think this is a very good move and really demonstrate that we really feel as attorneys also being employed in a company. And I think it's all said that the old picture of independency is not any longer true, maybe has never been true. Even lawyers, outside counsels, attorneys want to have some money for their advice and also want to have clients. The only independent persons I would say I know, these are the founders of SAPs, all are multi-billionaires, and I think they are really independent, and nobody is a lawyer. So I would say go away from this independency, and we have to look for is the independency with respect to the law, because we feel independent to give legal advice. Just maybe an anecdote, I was not admitted to the bar when I started with SAP, and I was asked by a public prosecutor to do so. There was an inside matter, inside case, where the public prosecutors investigated within the SAP. And they said, well, you are a victim, and so maybe, Mr. Junge, you would like to have a look to the files. I said, yes, very, very much. I really would like to have that. By the way, are you admitted to the bar? I said, no, should I? It would be better, he said. Then I went to my CFO and said, do you have any objections that I become a member of the bar? And he said, no, contrary, that's very good, fine. So I've got access to the files, even when I was not admitted to the bar. And I can tell you what, the day when I was sworn in at the courtroom as a bar member, at that day I really felt independent. And I'm still feeling independent. Because if I have problems with my employer, I can go as an independent attorney also and open my office or share other offices. Liability. In Germany, we have the so-called, I've tried to translate it, that I've not found the right term, so in any dictionary, the doctrine of damages inherent in somebody's works. It's meaning if you're doing work which is really risky, then the German courts are saying if you're doing a mistake and it's just negligent, then you don't have to pay any damages. If it's gross negligent, then you have to pay damages, and if it's willful, then you have to pay all negligence. This is also something I would say is also related to the day-to-day work we as counsels are doing. Insurance, Philip asked me also to give you some ideas about insurances. Of course, there's a D&O insurance. We at SAP, our D&O insurance also covers not just the member of the executive board, but also the directors, the so-called leitende Angestellte, and in particular, the head of the legal department. Just by the way, the insurance department is also reporting to me, so therefore I think we are covered. Then there are also some other possibilities, which are defense cost insurance for criminal prosecutions. This is the insurance we also have now signed on, and there is also another insurance for in-house counsels modified, which are the employment lawyers insurance. This is an insurance we do not have at SAP because we felt no necessity so much up to now. Also from my side, some words with respect to the privilege. We are aware of AkzoNobel, but also we are aware, for example, of the Belgacom case. And I would say now a triple hooray to the Belgium Appeal Court. I think that's absolutely the right direction. And on the one side, on the other side, as you, Mr. Tempeleng, already said, it's not only limited to antitrust and competition law, the privilege, it's much more. It's related also to any prosecution matters, coming from criminal matters, from public prosecutors, from regulators, but also, and this is something I think it has not been really covered until today, it also might be giving an impact on the civil cases with respect to the US jurisdiction. We all know that our colleagues don't have these discussions we do have in attorney-client privilege. This is really also true for in-house counsels. They are smiling at that or really cannot follow our decision or discussion. But they also, of course, being in-house counsels, also the privilege also appears to them. And I have not seen this until now, but it can happen that at a civil court in the US, maybe some of the plaintiff attorneys will stand up, or defendant attorneys stand up and say, hey, wait a minute, I have heard about AkzoNobel in Europe. The European in-house counsels don't have any privilege, dear Mr. Judge, so therefore all the papers in this civil case and documents laying at the offices in Europe, even in the legal department, are discoverable. And this really is something I think we should also address to the lawmakers, to the decision makers, that this is really a big, or can be a big disadvantage for all of us in Europe as in-house counsels. As I said, has not appeared so far, can happen. I have talked with some US colleagues and said, what do you think about that? And they were really surprised about this discussion, as I said, because for them it's such an inherent, basic theory of the US jurisdiction that there is a privilege, that they say that even not a local lawyer will really consider that in-house counsels may not have a privilege. But of course this can change, and I don't know, maybe also attorneys in the US maybe want to lobby against that, and so that we really have a disadvantage being here in Europe, and this is something which we have to highlight. And as also one of the other colleagues said, I think we also, as in-house counsels being employed by companies, we have to look for support of the industrial associations, companies associations of our board of management, because what we are discussing is not just for the merit of ourselves, but for the merits of the company and the executive board members. Everybody should be aware, and we really need to get this support. Maybe only one case in Germany, which is very interesting. You may have heard that 3 years ago there was a so-called HSH Nordbank case, which was an internal investigation done by a law firm on behalf of the supervisory board in order to see whether the executive board of this bank was liable with respect to some actions they did in the past. They made interviews, and they came to a legal conclusion. Then the public prosecutors asked the executive board or the company, please give us the legal opinion. The legal opinion was delivered to the public prosecutors. Then the public prosecutor said, okay, that's fine. Now we would like to have all materials, all interviews, all facts, everything you have written in your interviews, in your internal investigation, also to come to us as public prosecutors. Then the company said, no, attorney-client privilege. And we are not talking about an in-house counsels, but really external counsels. It was Freshfields. And the court decided, no, all this material has to be given to the public prosecutors, because there was not a client-attorney relationship between the interviewees, so the managers, and the attorneys. on the one side, and also there's only a privilege for defense lawyers. And at those days, of course, they were not acting as defense lawyers, but lawyers for the company. And so they had to give all these materials. But now the German Criminal Procedural Act has been changed. So Article 168 has been changed, which is now giving a privilege not only to defense counsels, but to all attorneys. And we already have seen a decision in Germany that a court said, or had to say, that now, with respect to all materials lying with the outside counsels or with the law firm, that they are privileged, even in cases of internal investigations. And as I said, it's a privilege for attorneys. In the Act, it's not limited to outside counsels or independent counsels or attorneys, it's to attorneys. So I'm really wondering whether maybe also a court may decide this is also true for in-house counsels, because all of us are aware that we are also working on internal investigations as well, and this is something I think we should also not jeopardize the trustful relationship to the management, but also to the people we are interviewing, because we are saying, okay, and they really have to give testimony on that because of their employmentship, whereas against the public prosecutors, they can be silent and say nothing about it. So last page. Compliance matters. As I said, no matter whether you have a compliance organization, a separate one, you also, as a general counsel or in-house counsels, you have some compliance functions. And this is also supporting our view that we are independent and that we have to say no or raise fingers if something is happening. The general the chief compliance counsel is reporting to me. For several reasons. One of the reasons was also the privilege, not from the European side, but from the US side, where we said maybe it's helpful if they have to give or should give something to the other side, to the other party, then we can say, okay, no, they are members of the legal department, and therefore their work is privileged as well. With that, I would say thank you very much, and sorry that I think I'm absolutely over time so far, but the clock, okay. The clock was not in front of me. Thank you very much.
Thank you, Michael, for this eloquent demonstration. You say that sometimes we have to say no. I think sometimes we have to be creative in solution, because saying just no will not help our campaign.